Welcome, evidence students. This is the first in a series of short videos in which I'll discuss some review problems. Most of these problems are drawn from prior exams. But before we talk about specific problems, I want to discuss how to spot issues on an evidence exam. I've seen over the years that many students have trouble spotting issues. The same problem arises in trial advocacy classes and law practice. There are so many potential objections to evidence. How do you hone in on the objections that will have the greatest payoff? Here are my 4 suggestions. First, create a checklist of the objections that parties can raise when they attempt to exclude evidence. This list will be much shorter than the number of topics we studied or the chapters in the book. There are some objections, like hearsay, that prompt lots of complex analysis. The book devotes 24 chapters to the rule against hearsay and its exceptions. But most of that material boils down to just 2 possible objections. The evidence violates the rule against hearsay, or the evidence violates the 6th Amendment. All of the rest is detail. You'll need to know that detail, of course, to analyze the potential objections correctly. But you can't begin your analysis until you have identified the possible objections. To do that, make yourself a list just of the objections that a party might raise to any proffered evidence. Some of the entries on that list might be relevance, subsequent remedial measures, character evidence, hearsay, and authentication. Note that some of these topics, like hearsay, cover many chapters in the book and raise a lot of sub-issues. Others, like an objection to evidence of a subsequent remedial measure or the failure to authenticate, are more compact. You want both types of objections on your list, but keep the list itself simple. Just list possible objections. Don't include all of the detailed analysis. I suggest that you begin your checklist with relevance, like the one here, and end the list with Rule 403, following the fishing net analogy described in Chapter 8. You won't address relevance or Rule 403 in every problem, but putting them first and last will help you think logically through each problem. Once you have your checklist of objections, you're ready for my second suggestion. Next to each objection on your list, note the fact patterns that can generate the objection. These should be simple notes, not complex discussions about the rules. For hearsay, for example, you might write, a party wants to introduce a statement made outside the courtroom. This includes oral statements and documents. For the 6th Amendment objection, write something like, the government offers hearsay against a criminal defendant. This annotated checklist will help you quickly spot issues on an exam. When you read an open-ended question, run your eye down your checklist. Look for situations that match the facts in the problem. Could the disputed evidence raise a relevance objection? What about character evidence or hearsay? You should be able to pick out a small number of objections that might apply to the evidence in the problem. Once you've highlighted those objections, you can turn to your more detailed notes and outline. A statement made outside the courtroom might not be offered for the truth of the matter asserted, or it might fit within one of the many hearsay exceptions. So it might be admissible even though you noted a possible hearsay objection. For each of the objections, you might create a checklist of issues within that objection. But create an overall list that just lists the objections, and that will help you target issues more quickly. Without the type of objection checklist I've described, students and new lawyers often overlook key evidentiary objections. Once you have your annotated checklist, it's time to begin attacking problems. And this leads to my 3rd tip. After you read an evidence problem, the very first question you should always ask is, what is the party trying to prove with this evidence? Ask that question even before you turn to your checklist. Understanding what the party is trying to prove will help you narrow down potential objections. If the evidence relates to the truthfulness of a witness, for example, you will look closely at the objections governing that type of evidence. Don't forget, though, to consider all of the possible objections. Some evidence can raise several different types of problems. That brings me to my final tip. If you see several objections to a piece of evidence, how many should you discuss? Well, first check whether the problem directs you to specific issues. If it does, analyze just those issues. You won't get extra credit for addressing additional points. If the question is open-ended, then you should consider all of the objections on your list. Once you've identified all possible objections, start with the most weighty one. If you see a strong objection to testimony on the grounds that it is character evidence, for example, begin with that analysis. Don't waste time writing that the evidence is relevant or that there's no hearsay involved. Conversely, suppose your checklist shows 2 or 3 weighty objections. In this case, allocate your time so that you're able to discuss each issue. A single witness might provoke objections based, for example, on both hearsay and privilege. You'll want to be sure to address both of those objections, even though they're quite different. And that's it. If you create a checklist of objections and annotate the list with the circumstances that generate those objections, you'll be well prepared for issue spotting. If you then approach questions by asking, what does the party want to prove with this evidence? Apply your checklist and analyze the most weighty objections first, you should hit the most important issues on the exam. In the next video, I'll analyze a problem from a previous exam, showing how these hints can aid your work.